what he was going to do. He already knew at that point, before Officer Curtis even made it back to his patrol car, this defendant, in his mind, knew what was going to happen. Brantley go with a warning. There's no hesitation, there's no delay, there's no time to calculate that age from that date of birth, extrapolating it forward to June 29th, 2010. I'd also ask you to consider the confidence in that voice, how confidently that individual is naming himself and spelling his name, the speed at which he does it, but the confidence in it. There's no, it's M-O-O-R-R-I-S-D-O, there's no hesitation. It's rapid, confident. That's the defendant. It's confident and rapid because it's his name. Now, Officer Curtis goes back to his cruiser. He runs the defendant's name. He pulls up his information. We saw that. If you could convert me back here, Ms. Blevins, I'd appreciate it. States A117, the photograph collected by Officer Detective Eric Houston. This screen was up in Officer David Curtis's car. It's got the defendant's identifying information on it, and it's got what Officer or Detective Houston told us is the defendant's photograph. Even though you can't see it because of the quality of the photo that was taken and the flash, that's the defendant's face. That's the defendant's photograph. If you could play that forward, Ms. Blevins, if you could advance it. Face. He's just seen his photograph on the computer screen. If that's not Dontae Morris, that officer would not be putting him under arrest for a warrant. He would be saying, what's your real name? That's why that identifying information is available on that computer with a photograph, so these officers on the street can confirm who they're dealing with, what kind of hazards they're dealing with, what kind of dangers they're dealing with. He had just seen his face on his computer screen, and now he's up there without hesitation, the officer now without hesitation, shining his light right in Mr. Morris's face. What's up with your warrant? He never hesitates. He doesn't say, what's your real name? I know your name's not Dontae Morris. What's your real name? Nothing like that. And of course, the inverse is true. If this was not Dontae Morris, and this was someone using his name fictitiously, once Officer Curtis says to him, what's up with your warrant? What do you think that guy in the front seat's going to be doing? Oh, I'm not Dontae Morris. That's not my name. Okay, I gave you a fake name, but I don't got a warrant. That's not my name. I'm not Dontae Morris. And when Officer Curtis tells him to get out of the car, he's going to be insisting, I'm telling you, I'm not Dontae Morris. You don't hear any of that. In fact, when he tells him to get out of the car, the front seat passenger, that defendant gets out of the car without hesitation, without any dispute. You can even kind of slightly hear him on there saying under his breath, okay, or something to that effect. This video is the strongest evidence in this case of this defendant's identity as the murderer of these two officers. He identifies himself to Officer Curtis. He does it in a fashion that only he could do, the actual person whose name it is. And Officer Curtis doesn't hesitate a minute when he eyeballs him, when he shines that high-powered law enforcement flashlight on his face after just looking at him on this computer photograph that I just showed you from the computer screen. This evidence alone, this evidence by itself, standing on its own, is enough to convict this defendant. This is proof beyond and to the exclusion of any reasonable doubt. And this is just the beginning of the evidence in this case. This is just the beginning. You're going to hear an instruction. Before I get to that, let me tell you this. You're going to see in this case that the evidence, all of this evidence, agrees, matches, dovetails with each other. You may have already have noticed that or seen it, how things overlap in this case. You've seen it in the evidence. Tamika Jones says that this guy Quelo, who she tells me she later learned to know as Dontae Morris, who she points to and identifies in court, who gave her a phone number which she identifies. He calls her at 2 o'clock in the morning. Detective Sal Ajiri testified to you. Ms. Jones gave her that phone number, and I'm going to get into that in a few minutes, and sure enough, at 2 o'clock in the morning, which almost is exactly what she said, in the cell records you can see this defendant calling her and texting her and using the name Quelo when she says, who's this? That's what I'm talking about. You'll see this evidence overlapping, layering, dovetailing. The judge will tell you that when you're weighing the evidence, when you're considering the evidence, some of the things you're to consider: did the witness seem to have an opportunity to see and know the things about which they testified? Did they seem to have an accurate memory? Were they honest and straightforward in answering the attorney's question? Did they have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Does it agree with the other testimony and other evidence in the case? That's called corroboration. And that's what shows you how inherently reliable evidence is when it overlaps and dovetails and agrees with each other and matches up. You will see that in this case. I want to talk to you about Ashley Price. Ms. Price is a very important witness in this case. She comes in here and she tells you that this defendant, who, and I have to respectfully disagree with counsel, she identified by pointing at him and describing a red sweater yesterday, who she identifies in court as Dontae Morris, told her that he shot and killed these two police officers on the morning of June 29th, 2010. Let's think about her testimony and go back to what she told us. We know from the testimony from her and from Detective Durkin that she went to the Tampa Police Department the day after the murders. There was nothing prompting or pushing her there. She didn't have any pending charges against her. That wasn't until the next month that she got arrested or had some charges put against her. She wasn't a convicted felon at the time. That didn't occur until a month or so later. She goes to the Tampa Police Department without any motivation, without anybody compelling her or prodding her or coercing her. They don't go to her. She comes to them. And she tells them, I have information about this case. She tells them that she knows Dontae Morris, and I'm showing you states T1. Thank you, Ms. Moore. And incidentally, I want you all to remember, this is the way Mr. Morris looked at the time, not the way he looks today here in court. Short cropped hair, low cut, a little bit of facial hair. She told the detectives that, and she told you in court, this defendant called her on the phone on the morning of the murders at 3:30 or so. After, of course, he text messages Courtney Brantley and says, I'm turning my shit off, was his way of putting it. He calls her from some phone, and he says, I need a ride. He doesn't say where he is, doesn't say who he's with. He says, I need a ride. Later that morning, which we know at that point that the murderer is on the run, that he has eluded the perimeter that was set up, and of course, that's understandable because he had a gigantic head start. It was minutes before those ladies found the bodies of the officers, and minutes after that before officers responded, and minutes after that before they started to establish a secure perimeter to try to capture who did this because they were worried about their fellow officers trying to save their lives. So that's consistent with him eluding that or getting outside of that perimeter and being on the run. Calls her, asks for a ride. She says no. Later that day, he calls her, tells her to look at the TV, tells her to watch the news. She does so. I did it. I killed these police officers. And this is where it really gets interesting in her testimony. She tells, and we know she told Detective Durkin this because Detective Durkin came in and told you what she told him back in the summer of 2010 on June 30th. She tells Detective Durkin that this defendant tells her he was a passenger in a car, that the officer got his name and went to run it, that he was afraid he had a warrant, that the officer came back, he got out of the car, and he shot the officer in the head, that there was 2 officers that he murdered, that he shot those crackers was the term he used, which means white, a white person, which they're white. These are the details that she gives Detective Durkin. And what is extremely significant about that is that that video has never been released to the press, has never been released. And you've seen the precautions taken while playing that video has occurred here in court. It has never been released to the press and hopefully never will be. The details that she gave to the police have never been released to the press. That these officers, well, not at the time they weren't. I take that back. At that time, between the murders of the officers and her interview on June 30th, the police had not released the fact that the officers were shot in the head. They had not released the fact that Officer Curtis obtained the names of the occupants and went back to his car to run them on a computer. They had not released the fact that Officer Curtis came up with a warrant and approached the passenger side of the car and was shot in the head, or what parts of the body Officer Curtis and Officer Kokab were shot in. Yet this young lady knows those details. There's no other way for her to know those details unless that defendant told her, because we know there's only 2 people involved in this case at that scene in that Camry. One of them is sitting right there, and the other one drove off that night, leaving those 2 officers there in the grass, like this defendant did. There's no other way, folks. So they can sit here and they can call her a 3-time convicted felon and say she got some monetary benefit. Detective Masucci told you about that. He had tried for months to get her assistance through charitable organizations, Metropolitan Ministries and other organizations, to get her and her children into an apartment. And they couldn't do that. It didn't work. So eventually the Tampa Police Department utilized $1,800 to get her last month's rent, security deposits, to get her into an apartment. That happened last month. That happened last month. What she told Detective Durkin, the same thing she told you, was 3.5 years ago. before any of this happened, these things with charges and being a convicted felon, she told you, and there's absolutely no evidence to the contrary, that she has received no benefits in her cases, never been offered any benefits or leniency for her testimony, doesn't expect any. None has come forward to this point. What she tells you is documented in that video. Overlap, overlaying, matching, corroboration. That shows you the accuracy and veracity of her testimony. Her testimony, standing alone. Based on her testimony, this defendant is guilty all day long on that testimony. That is proof in and of itself, standing alone, of his guilt beyond a reasonable doubt. Now, if you want any other evidence of the credibility of Ms. Price, you need look no further than the defendant's attempts from the Hillsborough County Jail in March of 2011 to try to contact her. The determined efforts he makes, the extent of the efforts he makes, these desperate efforts to contact a witness who's going to testify to his confession to her. You heard that jail phone call. It came in before her testimony. It may not have been as significant at the time when you heard it. Think about it now, and I'm going to play a couple of portions of it for you. I want you to hear the determination and the efforts in the defendant's voice to try to get to Ashley Price and get her to come see him. Before I move on to that, the one thing I would bring up to you, the point I bring up to you about Ms. Meek's argument about in her cross-examination towards Ms. Price about her familiarity with the defendant, this is the same man who says, I repent for killing in front of a complete stranger 4 feet away from him in the Hillsborough County Jail. All right? She's trying to suggest to you that this phone relationship that Ms. Price had with the defendant wouldn't have afforded the confidentiality that Ms. Price testified to. Well, that video tells you about the confidentiality and the accuracy of her testimony. She tells you she was intimate with him on one occasion. They talked on the phone. They didn't see each other very much. He called her every other day or so. She liked the fact that he liked the fact that she was quiet. And you heard her demeanor and the way she acted on the stand, very kind of quiet, meek young lady. If she was going to lie to you about the fact that he would confide in her, don't you think she would have come up with a much better story than that? That I saw him all the time, we had breakfast together, we went to lunch together, we were inseparable, we were soulmates. That tells you the credibility of her testimony. Now, I want you to think to yourself, why is this defendant so concerned in March of 2011 with talking with Ashley Price? Why is he so concerned that she's not, quote, righteous? Why is he trying to attempt to contact her and manipulate her? Because I would suggest to you there is almost no stronger evidence of guilt than attempts to cover up, to destroy, or manipulate inculpatory evidence, incriminating evidence. And he doesn't stop until he gets her on the phone. Remember how many people he goes through. 8 months after his arrest, he tells his good friend Pedro, Javante Denard, excuse me, let me quote properly, that shit there is the only thing holding me up in here. This defendant knows how critical her testimony is, and you can see by this phone call how threatened he is by it. Ms. Blevins, if you could play number 10 for me from the jail phone call.
No, it's like they got my life in their hands, right? You smell it? Yeah. Some food. It's something that I can, that little shit that whatever they got going on, it's something that I can get pushed out the way. But I'm trying to get it out the way now, you smell me? I ain't trying to wait all the way till months and months down the line to get it out the way, bro. I'm trying to go ahead and get it out the way now, bro. You smell me? Smell it?
You don't think he's threatened by her? Listen to that. She's got my life in her hands. My life is in their hands. You could play number 1 for me, Ms. Blevins. I want y'all to listen because he gets right to the point when his brother Dwayne Calloway gets him on the phone with his friend Javante Denard, who you learn through the testimony or through that phone call is the person who introduced him. And you also heard it through Ms. Price. That's more layering corroboration. In the defendant's phone call, he lays out how he met her. The same way she told you how she met him through her sister, Tiffany Price's boyfriend, Javante Denard. If you could play that for us, Ms. Blevins.
Hey, you hear me? Yeah. I need you to make a few moves, man. No problem, my nigga. I've been streaming that D-Lo spot, that feet, nigga. You remember who you and your lady had done put me down with? Yeah. Yeah, man. She unrighteous right now, man.
I need you to make a few moves for me. And she's unrighteous. Why is he trying to contact this critical witness against him? And when he does get a hold of her, through his brother, through Pedro, through Tiffany Price, who puts her on the phone, or does a three-way phone call to her sister. Can you play, Miss Blevins, number 4?
Yeah, I'm gonna. Hey man, when you get a chance, man, I need to talk to you, man. Yeah,
No, it goes on, I think. Is that number 4? Okay. Well, it goes on. He wants her to come down to the jail to visit her. And he gets right to the point with her. If you remember in that conversation, it's only a couple of sentences between the two of them. There's no idle chit-chat, how you doing, I miss you, anything like that. If you could play number 5 for us.
You know why I want to talk to you? Yeah. Well, I don't know. Well, not really. Tiffany just told me about the detective said something about a written statement. Why are you talking like that, man? You know why?
Okay. Why are you talking like that? Not why are you lying? Why are you making things up about me? Why are you talking like that? And then he doesn't tell her to go to the police and tell the truth, or go to his attorneys and tell the truth. He tells her, you need to come see me. He wants her to come to the jail to see him so that he can do the same thing that he did on the night of this murder when he contacted Courtney Brantley by text message. Is your car, it doesn't have to be at the spot. Is your phone in your name? This manipulation started right from the very beginning. And that was minutes after the murder this defendant was doing that. And I'll come back to that. Then he gets upset because in the conversation he has with her, she talks about a written statement and some detectives. So he calls Pedro back. He has his brother get Pedro on the phone, hit him back, I think is a term he uses. And he says, that shit there ain't even sound right. Sound like they had the people on the phone. Of course, the people are the police. We can tell that by the context of what he's saying. He's so upset he can't wait for her to get down there the next day. He has to call Pedro and find out what's going on. Why is she talking to the police? Why would he be afraid of her talking to the police if she's lying? Wouldn't he want her to go talk to the police? Why is he upset about that? This kind of evidence, folks, that kind of evidence, manipulation, trying to manipulate a witness that gives such powerful testimony, that kind of evidence simply drips. It drips with guilt. I mean, it stinks of guilt. And if you need any other evidence to show you the veracity, reliability, and accuracy of Ashley Price's testimony, you need look no further than that defendant's phone call to her in March of 2011. Now, we heard evidence about text records and cell phone records, and I want to talk to you about that a little bit. First, I want to talk about phone calls, or the phone numbers, excuse me. Dontae Morris's phone number. Detective Masucci told us that that phone number, through their investigation, they determined that he was using that phone number in the early morning hours of June 29th, 2010, the days before and the days after. Tamika Jones testifies that she has his contact with him, that when she's in contact with him, she sees him at Johnson Kenneth Court Apartments at about between 12 and 1 a.m. on the morning that the officers are murdered, and then around 2 o'clock he calls her. She says she has that number in her phone under the name Quelo. It's a number he gave to her before, a month or so before, when she gave him a ride on a prior occasion. I showed her her statement to Detective Sal Agiri, who also testified in this trial. She identified the phone number. Yep, that's the phone number I had in my contacts, and it was read into the record, 813-531-3906. Detective Sal Agiri testified that he received a contact number from Miss Tamika Jones of 813-735-8809. Now, Ms. Jones says that the defendant called her at 2 o'clock on the day of the murder. I just want to show this to you real quick. And knowing that that's her number, let's go back to the record information. (156:40), June 29th, 2010. These are the cell phone records, so the time is accurate for Eastern Standard Time. So at about 3 minutes and 20 seconds before 2 a.m., we see a minute 53 duration phone call from the defendant's number, 735-8809, Tamika Jones' phone number. You can't get any better corroboration than that. These records corroborate exactly what she told you happened that night. But they also show that it was this defendant's cell phone number. Now let's look at the text messages for this phone number, target number 531-3906. Same date, almost the same time. June 29th, 2010. And remember, you add an hour, because this is Eastern Standard Time, and that's central in the record. So it's 154:42 to the target number, 735-8809. Ms. Jones's number from Mr. Morris's number is, well, actually it's right above that, I guess. I'm sorry. The source number is her, and she's texting him. And she's texting him, "Who is this?" He responds to that same number, "Quelo, damn all niggas be at you like that." The same name that she identifies the defendant by, the same name that Ashley Price identifies the defendant by, and that, again, is a response from the source number, 531-3906. Folks, there's no doubt in the record, there's no doubt in this evidence. That phone number is that defendant's number he was using. That's a phone account he was using that night and the days before and the day after. Courtney Brantley, Detective Masucci told us, and this is the Metro PCS subscriber information, source number 863-844-1193, an address of 907 North Parsons Avenue, Brandon, Florida. An address owned by Michelle Washington, Courtney Brantley's mother, an address where Miss Brantley, Courtney Brantley, Detective Masucci testified, was there on several occasions when he went there and that she lived there. And Miss Brantley's cell phone records states R5, and this is target number 863-844-1193. Draw your attention to text originating on June 28, 2010 at about 3:23. I'm sorry, that would be 4:23 because you're adding an hour and it's military time, so 16:23. I'm sorry. You can see here that Ms. Brantley has texted this number at some point, and the number is now texting back and referring to her, because the destination number is the target number, the record number, Courtney Disrica. Her name's being used in these text messages. These are her cell phone records, her text messages. The record is clear. There is no doubt whose cell phones these two numbers were being utilized by at the time of the murder, on the night of the murder. Now I want to look at what these records tell us, because they paint a pretty good picture of what's occurring that night. This is States S, it's in Sierra. And I go to States R2, the defendant's cell phone records. You remember Detective Masucci's testimony about this diagram shows the tower location, shows phone calls being made, and at what time and what towers are being are the beginning and ending calls, or as counsel said, what towers the numbers are pinging off of. Closing. Let's start at 203. Or no, let's go back to 15640 is the outgoing call to Tamika Jones, 7358809, which is answered. That ends, it begins at tower 21, but ends on this tower, right up in this area up here, which of course, when he makes these next two calls, 03 and 203 and 204, these are outgoing calls at 203 to the mystery number, as counsel called it, 453-7397, and the 204 AM call off that tower is to Courtney Brantley, 863's number. He's calling Miss Brantley at 204, and then he had called her previously at 1:50 AM, outgoing call, which was originating and ending at this tower. Now that call's not on up there, it's not on the log up there, it happened at 1:50 AM. He calls her, that call, original call, is 2 minutes and 25 seconds. The next call to Miss Brantley is the 2:04 AM call off that same tower, and it's 29 seconds. Picking him up in the Camry, coming and getting him possibly, but we know they both are traveling in a red Camry heading south just after that when Officer Curtis intercepts him between Sly and Hillsborough Avenue on 56th Street, which becomes 50th here south of Hillsborough, north of Dr. Martin Luther King. Now, counsel talked about the mystery number 453-7397 as she talked about it, and she said it bounced off the same tower the whole night. Well, I beg to differ, and I think the record's going to show a little different. At the 203 call to that number, I'm sorry, to that outgoing call to that number is reflected up here at Tower 32. At 213, Mr. Morris is calling that number, and it's bouncing off of this tower down here, 230. So that's two towers that number bounces is coming through on the cell towers. At 216, Mr. Morris calls that number. It goes to tower 230 down on the bottom of the diagram. At 2:19:51, about 2 minutes after the murders, Mr. Morris is calling that number, and it's going to tower 24, which is over here, just to the east of the crime scene. At 2:22, Mr. Morris calls that same number, and it goes to tower 121 over here. So all four of those towers are being utilized for Mr. Morris to call that number. This map and these cell towers put the defendant, whose phone this was, we know through the testimony of Tamika Jones, a phone he was using 18 minutes before the murder, that he was talking to her on a phone call that bounced off up here, which is consistent with him being northbound on 56th Street. It puts him at the scene of the crime, around the crime. Now, would this evidence alone be enough to convict him beyond a reasonable doubt? No. But it is hard scientific corroboration of the other testimony in this case. It puts his cell phone right there. And remember, these towers are all within 1.5 miles of the murder scene, except for this one, which is about 5 miles away, up 50 to 56th Street. Perfect corroboration, perfect fit with that video, with the defendant naming himself, with Ashley Price's testimony. You're going to find there's nothing in the evidence that points away from the defendant. It all points towards him. Now, one thing I do want to address in these records, the defendant makes an outgoing call at 2:13:14 to that 453 number that we don't know whose account that is. It's a 3-minute call, so that would encompass the time that Officer Curtis comes to the window at 2:13:45. So that would be about 45 seconds into, or 30 seconds into that call. So for 2 minutes and 30 seconds after Officer Curtis's contact at the window with Courtney Brantley, that phone would have been activated. Does that mean that Mr. Morris had to be talking to someone on the phone for it to remain activated? No, it just means there has to be a connection through the lines. And who hasn't seen someone put their phone down when someone walks in to talk to them or approaches them to talk to them, especially a law enforcement officer questioning somebody? What is very dynamic about these text records that's different than the cell phone records, obviously, is that we get the content of the communication. The cell phone records, they show time, they show location. They don't tell us what's being said. These text records do. I've referenced this a few times already in my argument, or my summations. First of all, these text messages show us, and we just have to look really at the last few after the murder. They show us the relationship between these two people. I love you, Mr. Morris. Text Miss Brantley right here. She texts back, I love you to my last breath. 2 texts later, she texts, till death do us part, and he texts back, I'm out with love. If you look at the text messages in the pages preceding this, there's a lot of them. There's a lot of back and forth between them. Messages about her cooking food for him, meeting him somewhere, him bringing things to her. She's saying, I'm somewhere and I need some food, I'm hungry, can you come meet me, bring me some food? It's obvious that they're in a relationship. It's obvious that they have some type of romantic relationship going on. Maybe not monogamous, but a relationship. But those text messages show loyalty, number one, of Miss Brantley. And we know from the evidence, her loyalty, there really was no bounds or no ends to her loyalty. He texts her, the car doesn't need to be parked by the spot. We know from Detective Houston's follow-up investigative work in this case, states M19, that in fact she was located here in the Bristol Bay Apartments, 500 yards away, around the corner, where Detective Houston parked his silver Taurus, was where her Camry was found, backed into the spot, 500 yards away from where she was, which again is corroborative of the fact that this is Miss Brantley's cell phone, because she's saying, Still in here, but way around the corner. I need to move it somewhere else. He texts back, your phone and your name? No. And then he tells her to lean back and stay loyal. Now, he's already demonstrated her loyalty in parking that car and keeping it away from him. If you have any doubt about the relationship between the two of them, and we know in the cell records, she sends this series of texts after those. You haven't seen me. You don't know where I'm at. Please don't tell anyone anything. Erase these messages. When one of her friends of the 4 that she sent that to texts back, what? She texts back, just make like I never existed. Then she texts, no, it's okay. I'm not trying to start nothing, but you don't know me anymore. Please. Continuing to stay loyal, consistent with those text messages. The first text messages. And then when she's taken to the Tampa Police Department, we heard from Detective Duran, or from Mr. Henry Duran, who used to be a detective, that for almost 7 hours of questioning, she never identified the front seat passenger in that Camry. And that's not in dispute, folks. There's no dispute over who was driving that night. There's the driver, Courtney Brantley. Right here. It's just a picture from the DL. If you want to see a bigger picture of her. Oh, that's going to stay up there. Miss Brantley. She gives her DL to Officer Curtis. She's later found 500 yards away from the car. That was identified back to the scene by documentation and vehicle identification number. And of course, she discusses and exactly identifies in her cell phone records where she parked the car. There's no doubt that that is the driver of the car. And what is significant about that, I would suggest to you in these texts from the defendant to her. First of all, why is he telling her to hide the car and to stay loyal, and is the phone in your name if he's not the killer? Why would he be texting that to her in the minutes after the murder to her cell phone? How could he know that her car was involved in a murder if he's not the murderer? And why would he be texting her and telling her to do these things?
Already 15 minutes, sir.
Thank you, Your Honor. Ms. Tamika Jones testified. I talked about her testimony. I believe these cell phone records have shown you the type of corroboration that just shows ultimate veracity and honesty in her testimony and accuracy. She has shown that photograph, states K1. She identifies the defendant. She says he was dressed in those clothes, a dark blue vest, a white t-shirt. Those are the clothes that she identified him as wearing 2 hours before when they had contact in person. And I believe she writes on here, Detective Jerry testified that she wrote, it looks like him because of the head shape and the outfit that he has on. Here's a person that knows him, has had contact with him. She identifies not only his clothing, but identifies his face and head shape. Detective Duran comes in and tells you that after having contact with the defendant, probably about the same amount of contact in person that Ms. Tamika Jones did, seeing him when he was arrested, seeing him when he went to get the buccal swabs from him, and then watching hours and hours and hours of these video visitations, he tells you, after breaking down the film of this murder on that dash cam video and looking at this repeatedly, that in his opinion that is the defendant, Dontae Morris. I want to talk to you real quick about the voice identifications. You did hear several people come in here and make voice identifications, and I thought it was very, accurate, the cross-examination. Counsel would cross-examine each of these, especially Detective Duran, that there is no training for voice recognition, and he's right, there isn't. Does there need to be? We all have ears. Okay, we get voice training, as Detective Duran testified, from the time that we began talking and hearing people talk to us, being able to recognize, being able to recognize someone that you, a voice that you know, that you've heard, That's part of being a human being. That's part of the human brain, the mind, and the ears. That's part of life's experience. Now, Detective Duran has had thousands of interviews, and he worked on surveillances where he had to rely upon voice identification in situations where he couldn't see what was going on, and he was relying upon a body bug or some type of a microphone, a hidden microphone. But it's about exposure, and it's about familiarity based on exposure. Mr. Bolt asked Mr. Duran, I wanted to call him, keep wanting to call him detective, that's just one man's opinion. That's just one man's opinion. He's right, it is. But it's an educated opinion based on hours and hours and hours of exposure to that defendant's voice. You haven't had a lot of exposure to his voice. You've heard the video, the dash cam video a few times. You've heard portions from his jail phone call. If you need to listen to these things back there, listen to them. Go through them. It takes time to start recognizing someone's voice, but I would submit to you that the evidence shows this defendant's voice is very distinctive. It's a very distinctive voice that's very recognizable on that video. And it wasn't just Detective Duran who came in. Master Deputy Steve Gray from the Hillsborough County Jail, a security specialist from the jail came in. You remember him? He's kind of a big guy. He came and got up there and said, yeah, I've watched over 100 hours of video visitations. You have any doubt in your mind? No. No doubt. 110% that that's the defendant's voice. And he identified the defendant. Deputy Gellis came in. He said he's a jail deputy. He's worked around the defendant, worked in his unit for 8 months. He would walk by the defendant's cell throughout the day. He became familiar with the defendant's voice, and he was able to, without a doubt, identify the defendant's voice on that dash cam video, and he identified the defendant. So did Deputy Estrada, who had worked around the defendant for over a year, 5 days a week in 1 week, 2 days a week the next was his work hours. He identified the defendant. Deputy Camara came in. He had contact with the defendant for 2 years, frequent contact. And all these deputies said, except for Deputy Gray, they heard him talking in person, saw him talking to other inmates, and he would talk to them. This wasn't just video visitations. This was direct contact. Deputy Camara, without a doubt, identifies that defendant in court as being the same voice in that passenger in the dash cam video. All of these witnesses had substantial contact with him. They all could recognize him. I would encourage you, if you feel the need, to listen to the jail call, listen to that enrollment recording we put in. Remember that? To use the county jail, you have to do the enrollment. I want to play for you a few sections from the, you're going to hear sections from the jail phone call, from the enrollment, and from the video.
Dontae, D-O-N-T-A.
You want to play the next one? Ms. Blevins. I want to talk to you real quick, folks, about the law on first-degree murder. I only have a few minutes, so I'm going to be very quick here. First-degree premeditated murder. You heard the definition way back in jury selection, but it's killing with premeditation, which means killing after consciously deciding to do so. That decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill. However, the period of time must be long enough to allow reflection by the defendant. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt that at the time of there was existence of premeditation at the time of the killing. This is a factual determination to be made by you. But you look at the circumstances of the killing and how the defendant acted to make that determination. And I would suggest to you that what you saw in that video at the beginning of my closing was the product of a very cool, reflective thought process. He was waiting. Remember what Ashley Price told us? He's afraid he had a warrant. As soon as Officer Curtis left the door, he was waiting to see if those officers or that officer was going to come back, and he already knew in his mind what he was going to do. And he sat there in that front seat thinking about how he's going to do it. And think about this. As the officers approached, he didn't get out and start shooting out the door or doing this out the door. He didn't do anything but sit there and wait for them to come to him. He waited for them to get close to them, to get within distance, because his plan, as evidenced by that video, was to use the element of surprise and to use physical closeness. Dr. Krasowski told us these gunshot wounds were under 2 feet in distance from the muzzle. This defendant let them get in close, let them get very close to them so he wouldn't miss, so he could be effective. The speed and efficiency of this murder, of these 2 murders, shows you how planned, how premeditated this murder was. You can't commit a murder like this without premeditating. There's just no way to do it. And not only was it premeditated in advance, it continued through the process of the killing. You watch the video, he comes up and he shoots, and now he's got to fight the recoil in that gun, which is most likely, I submit to you from the evidence, a revolver, 38 Special or a 57 Magnum, because there's no shell casings, and the round is a 38 caliber class bullet, which includes 38 Special and 57 Magnum. But he's got to fight that recoil and get back and shoot again, and that's when he shot Officer Curtis that second round. That took determined action, thoughtful reflex and action. That took premeditation. You don't just do that. He knew when they were coming. He was laying in wait. This was an ambush. There is no doubt about that. I told you in the beginning of this case, the record would be clear. He ambushed these officers. There is a mountain, an absolute mountain of evidence in this case. And as I said earlier, it leads a trail, a path across this courtroom that leads right to this table, right to that defendant right there, Dontae R. Morris. As he said on the video, 8/24/85, there's no doubt in this case that he took the lives of these 2 young police officers. There is no doubt, and it is crystal clear in the evidence, that this was a cold-blooded murder. And there's no doubt in this evidence that this defendant gave those 2 police officers no chance whatsoever. He drew them in to his trap, and then he executed them. The evidence is clear. He's a murderer. He is a murderer, and that's what the evidence shows.
Mr. Warren, would you move this, please, sir?
Yes, sir.
Under the jury, I'm going to instruct you now the law. That takes about 15 minutes or so. Does anybody need a break before we do that? Yes? No? All right, for the benefit of the audience, I'm going to instruct the jury. If anyone wants to leave the courtroom, do so now. I don't want any movement in or out of the courtroom while I'm instructing the jury. And as we're speaking, the bailiff's going to hand you each a copy of the written instructions. Please write your name at the upper right-hand corner, because from time to time, if we find a typographical error, we need to correct it, collect them back. But you can make any underlines or notations that you want on these. You can have them with you when you go back to deliberate. I'm required by law to read them to you. I simply ask that we stay together, don't get ahead of me or behind me. Mia, do you need one? I remember the jury, Mr. Dontae Morris is accused of committing the crime of first-degree premeditated murder involving David Curtis in count 1, first-degree premeditated murder involving Jeffrey Cokehaven in count 2, and escape while transporting in count 3. You should consider the possibility that all the evidence may not convince you that he committed the main crime of which he stands accused in a particular count. There there may be evidence that he committed other acts that would constitute a lesser included crime as to that count. Therefore, if you decide that the main accusation in a particular count has not been proved beyond a reasonable doubt, you will next need to decide if he is guilty of any lesser included crime as to that count. The lesser crimes that are included in the definition of first-degree premeditated murder involving David Curtis in count 1 and first-degree premeditated murder involving Jeffrey Kokab in count 2 are second-degree murder either with a firearm or without a firearm, manslaughter either with a firearm or without a firearm. There is no lesser crime included in the definition of escape while transporting charging count 3. This next instruction is a general introduction to homicide. First-degree murder includes the lesser crimes of second-degree murder and manslaughter, all of which are unlawful. A killing that is excusable or that was committed by the use of justifiable deadly force is lawful. If you find that Dontae Mars killed David Curtis in count 1, Jeffrey Kokab in count 2, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder, or was second-degree murder, or was manslaughter, or whether the killing was excusable or resulted from the justifiable use of deadly force. Briefly, justifiable deadly force is defined as follows. The killing of a human being is justifiable homicide and therefore lawful if necessarily done while resisting an attempt to murder or to commit a felony upon Dontae Mars or to commit a felony in any dwelling house in which he was at the time of the killing. Excusable homicide is defined as follows. The killing of a human being is excusable homicide and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. We're on page 2. I will now instruct you on the circumstances that must be proved before Dontae Mars may be found guilty of first-degree premeditated murder or any lesser included crime. I'll now define the charges contained in count 1 and 2. The instruction is the same. To prove the charged crime of first-degree premeditated murder, the state must prove the following beyond a reasonable doubt. Number 1, David Curtis in count 1, Jeffrey Kokab in count 2 is dead. And 2, his death was caused by the criminal act of Dontae Mars. And 3, there was a premeditated killing of David Curtis in count 1 and of Jeffrey Kokab in count 2. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. The phrase killing with premeditation means killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow a reflection by Dontae Mars. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof for premeditation if the circumstances of the killing and the conduct of Dontae Mars convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. We will later need to refer to a subsequent instruction on the use of a firearm, which I'll read to you later. The lesser included offense of count 1 and 2 is second-degree murder, which I'll define for you. To prove the lesser crime of second-degree murder, the state must prove the following beyond a reasonable doubt. Number 1, David Curtis in count 1, Jeffrey Kokab in count 2 is dead. And 2, his death was caused by the criminal act of Dontae Mars. And 3, the killing of David Curtis in count 1, of Jeffrey Kokab in count 2, was by an act eminently dangerous to another, demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. We're on page 3. An act is deemed to be eminently dangerous to another, demonstrating a depraved mind without regard for human life, if it is an act or a series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and C, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove that Dontae Morris intended to cause death. And again, you'll later need to refer to a firearm instruction, which I'll read shortly. I'll next define the lesser offense of manslaughter. To prove the lesser crime of manslaughter, the state must prove the following beyond reasonable doubt. Number one, David Curtis in count 1, Jeffrey Kokab in count 2 is dead. And 2, A, his death was caused by the culpable negligence of Dontae Morris, or B, Dontae Morris intentionally committed an act or acts that caused his death. Dontae Morris cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. The killing of a human being is justifiable homicide and therefore lawful if necessarily done while resisting an attempt to murder or to commit a felony upon Dontae Morris, or to commit a felony in any dwelling house in which he was at the time of the killing. And again, the killing of a human being is excusable homicide and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune, in doing any lawful act by lawful means, with usual ordinary caution, and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune, in the heat of passion, upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune, resulting from a sudden combat, if a dangerous weapon is not used, and the killing is not done in a cruel or unusual manner. A dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a mere failure to use ordinary care toward others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct, on page 4, that Dontae Morris must have known, or reasonably should have known, was likely to cause death or great bodily injury. In order to convict of manslaughter by intentional act, it is not necessary for the state to prove that Dontae Morris intended to cause death, only that he committed an act or acts that was not merely negligent or justified or excusable, and which caused death. And again, later you'll have to refer to an instruction on the use of a firearm. I'll define the charge containing count 3, which is escape while transporting. To prove the charged crime of escape while transporting, the state must prove the following beyond reasonable doubt. Number 1, Dontae Morris was under arrest and in the lawful custody of a law enforcement officer. And 2, while a prisoner, he was being transported to or from a place of confinement. And 3, he escaped from custody. The phrase transportation to a place of confinement begins at the time an individual is placed under arrest. An arrest takes place when the arresting officer intends to arrest, the arresting officer actually or constructively seizes the person to be arrested, the officer's intent to arrest is communicated by the arresting officer to the person to be arrested, and the person to be arrested understands that communication. An arrest does not require that the law enforcement officer complete the act of acquiring total physical control over the person to be arrested. This next instruction has to do with the use of a firearm, and it applies to count 1 and count 2 and the lesser offenses. If you find Dontae Morris guilty as charged of first-degree murder, or guilty of the lesser offense of second-degree murder, you must further find and determine beyond reasonable doubt and reflect in your verdict form as provided therein whether, in the course of committing the offense, A, he actually possessed and discharged a firearm and caused the death, or B, he actually possessed and discharged a firearm, or C, he actually possessed a firearm, or D, he did not possess or discharge a firearm. To actually possess a firearm means to have it in one's hand or hands or on one's person. If you find him guilty of the lesser offense of manslaughter, you must further find and determine beyond reasonable doubt and reflect in your verdict form as provided therein whether in the course of committing the offense, A, he carried, displayed, used, threatened to use, or attempted to use a firearm, or B, he did not carry, display, use, threaten to use or attempt to use a firearm. And a firearm is defined as any weapon which will expel a projectile by the action of the explosive and includes the frame or receiver of such weapon. We're on page 5. This next instruction has to do with burden of proof and reasonable doubt. Dontae Morris has entered pleas of not guilty. This means that you must presume or believe that he is innocent. This presumption of innocence stays with him as to each material allegation in the charging document as to each count, as with each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome his presumption of innocence, the state has the burden of proving that the crime with which he is charged in a particular count was committed and that he is a person who committed that crime. He is not required to present evidence or to prove anything. Whenever the phrase reasonable doubt is used, you must consider the following. A reasonable doubt is not a mere possible doubt or a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty as to any count if you have an abiding conviction of his guilt as to that count. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction of his guilt as to a particular count, or if you have a conviction, it is one which is not stable but one which wavers and vacillates, then that charge is not proved beyond every reasonable doubt, and you must find him not guilty of that count because your doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of Dontae Morris as to any count may arise from the evidence, from conflicts in the evidence, or from a lack of evidence. If you have a reasonable doubt as to any count, you should find him not guilty of that count. If you have no reasonable doubt, you should find him guilty. These next instructions give you some guidance as to how to go about weighing the evidence and instruct you as to eyewitness identification. It is up to you as jurors to decide what evidence is reliable. You should use your common sense in deciding which evidence is the best evidence and which evidence should not be relied upon when you consider your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some specific things you should consider are the following. 1. Did the witness seem to have an opportunity to see and know the things of which that witness testified? 2. Did the witness seem to have an accurate memory? 3. Was that witness honest and straightforward when answering the lawyer's questions? 4. Did the witness have some interest in how the case should be decided? 5. Does that witness's testimony agree with the other testimony and other evidence in the case? 6. Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7. Had any pressure or threat been used against the witness that affected the truth of that witness's testimony? 8. Did the witness have some other time make a statement that is inconsistent with the testimony he or she gave in court? And 9. Has the witness been convicted of a felony or of a misdemeanor involving dishonesty? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. We're on page 6. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give an opinion. However, an expert's opinion is only reliable when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all of an expert's testimony. You must consider the testimony of some witness with more caution than others. For example, a witness who has been promised immunity from prosecution or who hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about Dontae Morris. So while a witness of that kind may be entirely truthful when testifying, you should consider his or her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond reasonable doubt of Dontae Morris's guilt, or the other evidence of the case does so, then you should find him guilty. It is entirely proper for a lawyer to talk to a witness about what testimony that witness would give if called to the courtroom. A witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. You have a testimony of eyewitness identification. In deciding how much weight to give this testimony, you may consider the various factors mentioned in these instructions concerning credibility of witnesses. In addition to those factors, in evaluating eyewitness identification testimony, We may also consider 1, the capacity and opportunity of the eyewitness to observe the alleged offender based upon the length of time for observation and the conditions at the time of the observation, including lighting and distance. 2, whether the identification was a product of the eyewitness's own recollection or was a result of influence or suggestions. 3, the circumstances under which Dontae Morris was presented to the eyewitness for identification. 4, any inconsistent identification made by the eyewitness. 5, any instance in which the eyewitness did not make an identification when given the opportunity to do so. 6, the witness's familiarity with the subject identified. 7, lapses of time between the event and any identification. 8, whether the eyewitness and the alleged offender are of different races or ethnic groups, and whether this may have affected the accuracy of the identification. And 9, the totality of the circumstances surrounding the eyewitness' identification. This extra instruction had to do with the defendant having not testified. The Constitution requires the state to prove its accusations against Dontae Morris. It is not necessary for him to disprove anything, nor is he required to prove his innocence. Rather, it is up to the state to prove his guilt by evidence. Dontae Morris exercised a fundamental right by choosing not to be a witness. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should be concerned that he did or did not testify at trial. Page 7. The following instruction gives you some rules to deliberate. The following are some general rules that will apply to your discussion. You must follow these rules in order to return lawful verdicts. Number 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law. Everyone is depending upon you to make a wise and legal decision. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or because you are angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in any way. 5, your duty is to determine as to each count if Dontae Morris has been proved guilty in accordance with the law. It is a judge's responsibility to determine a proper sentence if he is guilty of any count. 6, whatever verdict renders to each count must be unanimous, which means that each juror must agree to the same verdict in each count. 7, it is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. A witness should not be discredited by talking to a lawyer about his or her testimony. 8, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdicts must be based on the evidence and on the law contained in these instructions. Deciding verdicts is exclusively your responsibility as jurors. I cannot participate in that decision in any way. Please disregard anything that I may have said or done that makes you think that I prefer one verdict over another. A separate crime is charged in each count of the charging document, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not necessarily affect your verdict as to any other crime charged. We're on page 8. As to each count, you may find Dontae Morris guilty as charged in the charging document, or guilty of just lesser included crimes the evidence may justify, or not guilty. If you return a verdict of guilty as to any count, it should be for the highest offense which has been proved beyond a reasonable doubt. If you find that no offense in a particular count has been proved beyond a reasonable doubt, then of course your verdict as to that count must be not guilty. Only one verdict are returned as to each crime charged. Again, each verdict must be unanimous, which means that all of you must agree to that same verdict. The verdict must also be in writing, and for your convenience, the form has been prepared for you. If you'll turn to the last, I guess, 2 pages of your packet, there's a sample verdict form right there. It has the style of the case number, it reads the State of Florida versus Dontae Morris, and it reads as follows. We, the jury, find as follows to count 1, and you must check only A, B, C, or D, plus any other specific finding. A, the defendant is guilty of first-degree premeditated murder involving David Curtis, which is as charged. If you so find, you must further indicate whether he actually possessed and discharged a firearm and caused the death, or whether he actually possessed and discharged a firearm, or whether he actually possessed a firearm, or whether he did not possess or discharge a firearm. B, the defendant is guilty of second-degree murder, which is lesser offense. If you so find, you must further indicate whether he actually possessed and discharged a firearm and caused the death, or whether he actually possessed and discharged a firearm, or whether he actually possessed a firearm, or whether he did not possess or discharge a firearm. C, the defendant is guilty of manslaughter, which is lesser offense. If you so find, you must further indicate whether he carried, used, displayed, attempted to use, or threatened to use a firearm, or whether he did not carry, use, display, attempt to use, or threaten to use a firearm. D, the defendant is not guilty. The second page of your verdict form reads, we, the jury, find as follows account 2. You must check only A, B, C, or D plus any other specific finding. A, the defendant is guilty of first-degree premeditated murder involving Jeffrey Tocab, which is as charged. If you so find, again, you must further indicate whether he actually possessed and discharged a firearm and caused the death, or whether he actually possessed and discharged a firearm, or whether he actually possessed a firearm, or whether he did not possess or discharge a firearm. B, the defendant is guilty of second-degree murder, which is a lesser offense. If you so find, you must further indicate whether he actually possessed and discharged a firearm and caused the death, or whether he actually possessed and discharged a firearm, or whether he actually possessed a firearm, or whether he did not possess or discharge a firearm. C, the defendant is guilty of manslaughter, which is a lesser offense. If you so find, you must further indicate whether he carried, used, displayed, attempted to use, or threatened to use a firearm, or whether he did not carry, use, display, attempt to use, or threaten to use a firearm. D, the defendant is not guilty. We, the jury, find as follows count 3. Again, you must check only A or B. A, the defendant is guilty of escape while transporting. B, the defendant is not guilty. And there's a place for the date and a place for the signature and the printed name of your foreperson. Please turn back to page 8 of your packet. In just a moment, our bailiff will take you to the jury. The first thing you should do is to choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's responsibility to decide to take the verdict form when you've all agreed on the verdict, and then to bring the verdict form back to the courtroom. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You're not to communicate with any person outside the jury about this case. Until you reach a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as a blog, a Twitter, an email, a text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions, or any other instruction I've given you in the case, you must tell me by giving a note to the bailiff. If you need to communicate with me, please send a note to the bailiff signed by your foreperson. If you have a question, before I can respond, what I must do is get the lawyers together, the defendant, the court reporter, and the clerk to discuss your question to determine first whether it's something that we legally procedure can answer, and if so, how we go about answering it. So there'll be some delay in our getting back to you if you have a question. You may, of course, continue deliberations while you wait for my answer. I will respond to any question in writing directly on your written note. So therefore, please do not discard any note or written answer I give you. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberation. The exhibits will be sent to the jury with you when you begin to deliberate, as will a copy of the charging document and the original verdict form. And by the way, the verdict form that you need to execute is this one that says original at the top. Yours is simply a second. You may not see documents such as police reports or depositions or written statements or demonstrations of aids that may have been discussed during the trial but not actually placed into evidence with our clerk. You will also have your notes and your own copy of the instructions I gave you. There are no instructions or definitions applied to this case. Again, your verdict finding Dontae Morris either guilty or not guilty has to be unanimous. The verdict must be the verdict of each juror as well as the jury as a whole. In closing, let me remind you that it's important that you follow the laws set forth in these instructions when you decide your verdicts. There are no laws that apply to this case. Even if you don't like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has a right to violate rules that we all share. State anything additional?
No, Your Honor.
Counsel, anything additional?
No, Your Honor.
Okay. The bailiff's going to take you to the jury with the exhibits. Now, we get to the point of the matter of alternates. I told you folks at the beginning of the trial that there would be 12 of you jurors and 4 of you were alternates, and the 4 alternates did not know who you were. The alternates do not go back to deliberate. However, your service is not ended. I have some special instructions for you. In this case, these are our 4 alternates. James Grogan, Douglas Marks, Charles Coleman, and Sergey Beth Munch. Okay, and you 4, please remain seated for just a moment, and the other 12 of you, please go with our bailiff, and you'll have all the exhibits and whatever.
All rise. You will bring a couple of exhibits.
You can all be seated. Okay, Mr. Coleman, Mr. Marks, Mr. Grogan, and Ms. Mungy, you will forward all this. Was I aware of that fact? Was it, okay. I need to read you an instruction now. This is a bit unique because, as we told you at the beginning, if in fact the jury finds Mr. Marks guilty of first degree murder, there will be a second proceeding. If they find him not guilty or guilty of some lesser offense, there will not be a second proceeding. I'm going to read you an instruction now, and I'll give you each a written copy of this, and we'll work out the logistics of what we have to do next momentarily. I'll read this to you now. As an alternate juror in a non-capital case, you would be excused at this time. However, because this is a capital case, procedures require that you remain available in the event of a second phase. Therefore, at this time, you are not excused, but you will be in recess until further notice. If a second phase is required, you will be required to return at that time to listen to evidence, arguments, and instructions of law, either with your fellow jurors, or if something should happen to prevent one of the other 12 jurors from participating, you would then fill in for that juror, and 12 of you would then deliberate to arrive at advisory verdicts. However, if all 12 of your fellow jurors are present for and through the second phase, you would then be excused and relieved as an alternate juror. Accordingly, I must order you still to not read, watch, or listen to your reports about this case. Do not discuss this case with any person, and do not speak with the attorneys or the witness about anything. Do not access the internet or engage in any online discussions such as a blog, a chat room, Facebook, or Twitter. Should a second phase not be required, we will advise you immediately. If a second phase is required, we will advise you of the exact time, date, and place by telephone. The bailiffs have all of your contact information. The date, the proposed date in the event of a second phase proceeding will likely be this next Tuesday, November 19th, and the bailiffs will coordinate your transportation should that become necessary. I do sincerely apologize for this convenience, but this procedure is required by law. Your 12 fellow jurors, if a second phase is required, will receive similar instructions and admonition. Your notepad with your notes will be returned by the clerk under seal and will be returned to you if a second phase takes place. If not, your notes must then be destroyed. But I promise you that no one will ever look at your notes. Please make certain that the bailiffs have your correct contact information. We'll give you each a copy of this instruction. I do want to thank you at this time. You'll be in recess now. Logistically,
one thing, Your Honor, may I approach?
yes, sir. Some options, either stay the night and be transported tomorrow morning at your hotel, or they can make arrangements to transport you. They'll have to work that out with you, but the plan is right now, if a second phase is required, the bailiffs are going to go over there Monday night, spend the evening, and they're going to pick up all the jurors, yourselves included, should that be necessary, and bring you all back here early Tuesday morning. We anticipate that if a second phase takes place, it would take that one day. However, should it go into the next day, which is very doubtful, I'll admonish you and your fellow jurors to bring at least one change of clothes for the evening. We don't anticipate it to be necessary, but it may be. So before we recess you, any questions? I do apologize for this. I know it's normally speaking, in non-capital cases, alternate jurors will be excused at this time to be over, but the law requires this, and it's an inconvenience, and I do apologize. Our bailiffs will coordinate things with you as far as getting to the hotel and transporting you back. Lieutenant?
Yes, sir. We're ready.
Are you ready?
Ladies and gentlemen,
You have one? You can all be seated. All right, counsel, it's 3:30, I'm sorry. You leave your cell phones with Marcy, and we'll be in touch with you as to how we decide to proceed. Either let these folks go into the evening, or if they want to recess and come back tomorrow morning, then we can do that.
yes. Okay.
Council gave each a copy of this order, gave to the alternates. Coordinate the post for the next day.
I think we can do it, it's just.
The reason I didn't want to do this, I didn't want to rush things. I want to iron out what all the acts are, the litigation. You said you wanted this, so we haven't gotten anything yet to include. And get that all up on that Monday. Otherwise, I have to keep it all. I should have included you guys in that.
I just want to make sure, we are Tuesday.
You want to wait, this may change. We may talk to the 12 people and say there's no way. Yeah, to change it.
I see what you're saying. Okay, thank you. Oh, I'm sorry, are we supposed to be you?
I got your number, I think.
Got myself?
Changed it.
All right, we go on. Send it down there. It's clean. No documents, there's nothing. Yeah.
I'm gonna do it. Yeah, I ain't there, but I wish that. Well, your guess is as good as mine, You'll be all that back to Monday.
premeditation. You don't just do that. He knew when they were coming, he was laying in wait. This was an ambush. There is no doubt about that. I told you in the beginning of this case, the record would be clear. He ambushed these officers. There is a mountain, an absolute mountain of evidence in this case. And as I said earlier, it leads a trail, a path across this courtroom that leads right to this table, right to that defendant right there, Dontae R. Morris. As he said on the video, 8/24/85, there's no doubt in this case that he took the lives of these two young police officers. There is no doubt, and it is crystal clear in the evidence, that this was a cold-blooded murder, and there's no doubt in this evidence that this defendant gave those two police officers no chance whatsoever. He drew them in to his trap, and then he executed them. The evidence is clear. He's a murderer. He is a murderer, and that's what the evidence shows.
Mr. Warren, would you move this, please, sir?
Yes, sir.